Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On the show, I should be able to cover a vast diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please feel free to get in touch. Two ways to get in touch with us. First of all, you can ring us on the landline number which appears at the bottom of the screen. Your call will be put through to me live in the studio here and I'll be able to discuss your query live on air. Secondly, another popular way of getting in touch is to send a message, a WhatsApp message, a text message on the mobile number which appears at the bottom of the screen. Always a very popular way of getting in touch. So your questions, whether it's on WhatsApp or whether it's on text, please do keep on sending those in. They will be fed through to me here live in the studio and I'll be able to address your question live on air. If my answer is not clear, then by all means follow it up with another question, or as always you can give us a ring and we can discuss it live on air on the landline number which is there at the bottom of the screen. Couple of minor points before we get going. Obviously, on a live show, it's not possible to take very detailed information from viewers who call in. If your matter is complex and I need to take very detailed information, then I'll ask you to leave your number with the control room. And if I need to look at your documents before I can advise you properly, sometimes, for example, if it's an immigration matter, you might have received a refusal letter, or you might have gone to court and your appeal has been refused. It's then probably better if I look at that document and I then have a discussion with you in terms of what your options are, what your next steps are. So if it's the case that the matter's complex or I need to look at your documents, then I'll advise you to leave your number with the control room and I will have that more thorough discussion with you off air. And that service is a service that we provide absolutely free of charge, part of the free legal advice show. So don't be concerned if your matter is complex. Do get in touch. If it's complex, I will speak to you off air. It's not a problem. I can advise you properly off air and there is no charge whatsoever for that. So as I've said, two ways to get in touch, landline number and the mobile number. The mobile number is there only for you to send messages in. Now, just before we've come on, we've had a number of questions that have been coming in. And just before we started the show, I was trying to go through some of the questions to work out what the best practical solution is in relation to the question that's been posed. Let's look at one of the first questions that's come in. Let me read the question out and then let's look at what the answer to that is, what the options are. First question that's come in is as follows. My wife came to the United Kingdom as a tier 1 partner, as a tier 1 dependent, tier 1 partner. And then later on, she got further leave to remain in the United Kingdom under the 10-year route. So partner comes to the UK as a tier 1 migrant. So it might have been the partner of an entrepreneur, but then later changes the route to a different route. Now, I will address this in greater detail after we've taken our first call for the day. Hello, assalamu alaikum.
Wa alaikum salam.
Jibe, thank you for calling. What's your question?
Hello.
Hello, brother. You're live on air. You're live.
Hello.
I can hear you. What's
Hi,
your...
assalamu alaikum.
Wa alaikum
I have a
salam.
quick question.
Okay.
The EEA family permit was applied for a person from Pakistan, which was refused initially because it was an indirect relationship
Okay, I understand.
between the applicant and the who was sponsoring from here under the EU law.
Okay.
He was originally refused and then obviously went to the appeal stage. Appeal was allowed actually. And then 15 days are passed for the Home Office to appeal. They did not appeal. So I wanted to ask, what is the next step and who do we need to contact and what is the time scale now
Okay.
for the next stage?
So in terms of the family permit, has the appeal been successful?
Yes, successful. Yes.
Successful. So the judge has said that the person should be granted a family permit to come to the UK. Can I just
That's
ask then that this is quite important, that what's the relationship between the sponsor in the UK and the applicant who is applying for the family permit? What's the relationship?
It's a nephew, and
Right.
his
So
nephew.
it's an extended family member appeal.
Extended family. That's
The,
right.
the problem is this at the moment, that what will happen is this, and this is completely unsatisfactory, but this is what's going to happen. You have won your appeal, and you would normally expect that if you win the appeal, the next step is that the Home Office will grant the family permit. But at the moment, they won't do that for extended family members. What they will do is this. A couple of weeks down the line, or a month or so down the line, the applicant will receive, or the appellant will receive, a letter basically saying that your appeal was successful. However, from the 30th of June or the 31st of December, can't remember which date it is, from that particular date, we have stopped issuing family permits for extended family members. And therefore, although your appeal has been successful, we can't issue you with a family permit. So that's the next thing that's going to happen. Completely unsatisfactory. Now, this issue at the moment about where an extended family permit appeal has been successful and the Home Office is refusing still to issue a family permit is the subject of judicial review proceedings at the moment. So that approach of the Home Office is currently being challenged at the moment. So at some stage, if the applications, the judicial review applications which are ongoing, if they are successful in favour of the applicants who are abroad, who are waiting for family permits to be issued, I suspect what will happen is that everybody who's in this situation, whose appeal for a family permit has been successful, but they've still been denied a family permit, I suspect they will all be granted a family permit later on. Does that, brother, does that answer your question, or does that complicate matters for you? Hello?
Yeah, that's good. Yes, yeah, that's answered my question.
So you're going to have to wait practically, and it's going to be bad news. But don't worry too much, because that approach that the Home Office is taking, which is completely unsatisfactory, is the subject of challenge at the moment. That issue is going back to court at the moment, saying this approach where somebody wins and you don't issue the family permit, that's completely wrong. So that's been challenged at the moment.
Yeah, you're right. I don't understand how the Home Office could go against the decision, court's decision. So, yeah, obviously you are a lawyer.
Yeah, it just doesn't make sense. What the judge is saying is that your decision, the Home Office, your decision is wrong. Well, if it's wrong, the family permit should have been granted at that stage. You made an incorrect decision. Why are you penalising somebody now and hiding behind timelines and saying we don't issue family permits anymore? If you'd done the assessment properly, the family permit would have been issued when the initial application was made instead of being refused. So, look, don't be too disheartened. The matter is currently being challenged. Just sit and wait, basically, in terms of what happens. Let this unfold.
Okay, great. Thank you very much.
Thank you. No problem at all. Thank you very much for your call. So just before that call, we had a question that on WhatsApp, which I was addressing. So let me just go back to that question again. And the question is as follows. My wife came to the United Kingdom as a Tier 1 partner. Then she got further leave to remain on the 10-year route. So basically, what's happened is the partner enters under one particular route, the Tier 1 route. Later on, she transfers, still as a partner, but under a different route, under the further leave to remain route, under the 10-year route. The question that's been posed is this, that she has now been in the United Kingdom for 6 years. Does any of the previous time count towards indefinite leave under the 5-year period and under the long residence period? Now, the basic position is this. You know, when you switch from a Tier 1 partner category into a spouse category, whether it's a 5-year or 10-year category, then for the purposes of the family route to settlement, whether it's 5 years or 10 years, for the purposes of those routes, the previous leave under Tier 1 doesn't count. So only the visa that's granted under the family route counts towards the 5 years or 10 years that need to be completed in order to get indefinite leave under that particular category. So if you've done 4 years as a tier 1 partner, so you might have been the wife of an entrepreneur, you've done 4 years there. You come over, for whatever reason, you give that route up, you come over just as a spouse, and you start your visa leave to remain again as a spouse. You're not going to be able to add both periods of residence for the purposes of that family route settlement, whether it's under 5 years or 10 years. So that's the basic position. However, there is another route which our viewers who listen or watch this show will be aware. There is another route, and that is where somebody has actually lived in the UK for 10 years, the 10-year long residence. So it's not the family route to settlement. It's not some kind of tier 1 or points-based system route to settlement. It's a long residence route where somebody has lived in the UK for 10 years legally. As far as that route is concerned, that route can be made up of different types of visas. So it could be tier 1 migrant, it could be student dependent, it could be a spouse, it could be anything. As long as you have spent 10 years in the United Kingdom legally, you do qualify for indefinite leave to remain. So for the purposes of that family route, which has its own 5-year, 10-year route, you can't add different routes together, different types of residence together. You have to qualify under that particular route. However, where it's a long residence application, 10-year long residence application, that's completely different. You can add the different types of leave that you've been granted to get up to your 10-year mark. So hope that is a thorough answer to your question. If you're not sure, please do come back to me and I'll try and clarify the position for you. We're going to be taking a short break. We'll be back in the next couple of minutes. Inshallah, see you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air with any legal questions that you have, please ring on the landline number which appears at the bottom of the screen. And as always, in terms of messages that you want to send in with your questions, please do so on the mobile number. So to speak to us live, do call on the landline number. Messages you can send through on the mobile number, which is there at the bottom of the screen. Now, we've had a number of WhatsApp messages coming in, which is fantastic, but please do feel free to pick up the phone and speak to me live as well. Right, let's look at the next question that's come in. Question regarding nationality and minor criminal offences, what the impact of minor criminal matters are on a nationality application. Questions from MS Shazad. Let's have a look. Question is, I have a question about a nationality application. I got my leave to remain card in 2018. I'm assuming it got indefinite leave to remain in 2018. Okay. That's why we've now got the question about nationality. Question is this: I have got 6 points on my license for driving without insurance, and that happened in November 2020. Is it okay for me to apply for nationality? Any advice would be appreciated. So, looking at the question, it looks like indefinite leave to remain was granted in 2018. Now, our viewer is considering applying for nationality. But the problem is that, unfortunately, and this is easy to do, our viewer has managed to get 6 points on his or her license. Now, what's the effect of that? Now, the basic position is this. You need to look at how you got the 6 points. Did you get the 6 points by way of fixed penalty? Or did you get the points after an appearance at the magistrate's court? Now, if it's the former, if you get fixed penalty points, if you get fixed penalty fine, then the Home Office will generally disregard that. There is no waiting period. The Home Office will disregard it. Whether you get 3 points speeding, 3 points for speeding, you get 3 points for speeding again, or whether it's 6 points for insurance. Generally, fixed penalty offences will be disregarded when looking at criminality and the restriction on obtaining nationality where you have criminal convictions. So fixed penalty matters are generally not taken into account. Now, if on the other hand, the 6 points was as a result of the matter being referred to the magistrate's court, and it's the actual court which issued the points, and then there would be a fine as well, then the position is slightly different. A matter which is disposed of in court by way of a fine, so it's a non-custodial sentence, it's matter disposed of by way of a fine, normally means that you are unable to apply for nationality for a period of 3 years. So 3 years is the waiting period. So that's the distinction. Was it dealt with by way of fixed penalty, or was it dealt with at the magistrate's court? If it's a fixed penalty matter, there's no waiting period, you can still apply for nationality. On the other hand, if it's something that went to court, then there is a waiting period basically of 3 years. And that applies to any matter which is dealt with in court, which results in a non-custodial disposal, such as a fine and similar, might be a community service, etc. All matters where the sentence is non-custodial in the magistrate's court generally will mean that you're prevented from applying for nationality for 3 years. Hope that answers your question. Okay, let's look at the next question that's come in. My cousin is on the 10-year route to settlement. They have British children. Someone has told them that because of the British children, there is no need to pass the life in the UK test. Is it true? The short answer is it's not true. When you apply for indefinite leave to remain, whether it's under the 5-year route or the 10-year route, there is a requirement in terms of English. There are 2 requirements. One is you have to pass the speaking and listening test in English at B1 level, and you have to pass the life in the UK test as well. So just because there are British children, just because you're on the 10-year route, doesn't mean that at the end of 10 years, the English requirement ceases to apply. That's not the case at all. Having British children also makes no difference at all. In the vast majority of cases where you're applying for indefinite leave to remain, and certainly as far as the 5-year, 10-year category, family type categories are concerned, which lead to settlement after 5 or 10 years, there is an English requirement. And as I said before, it's fulfilled by doing not 1, but 2 tests. One is the speaking and listening test, where they want to assess your ability to speak English, and the life in the UK test, which is a test about your knowledge relating to the United Kingdom. So both tests do need to be done when you're applying for indefinite leave to remain under these family leave to remain categories. And that's the case with the vast majority of immigration categories. There's always an English requirement generally. Now, we've got loads of immigration questions that have been coming in today, which is absolutely fantastic. Slightly different question as well that's coming. So let me look at that first before we go back to our immigration questions. And the question is this. If you were to find money on a pavement or anywhere else on the floor, can you keep and use it? So interesting question, slightly different to our normal immigration law question. So if you're lucky enough to find money somewhere, pavement or on the floor somewhere, the question is, from a legal point of view, can you keep it? Well, it is actually an interesting question as to what you can keep, what you can't keep. If I give you an example, not necessarily about money, but about goods, about maybe a telephone, a mobile phone. Can you keep it? Well, the short answer is this. You've got to look at whether somebody has actually abandoned that thing or not. And the reality is anything of value is unlikely to have been abandoned. So but if something has been abandoned and you keep it, it can't be theft at that stage. But if it hasn't been abandoned and you found something, the short answer is you can't keep it. Potentially, it could amount to a criminal offence of theft if you do keep it. I'll come back to this in a bit of detail after I've taken our next call. Hello, Assalamu alaikum.
हेलो
Hello.
जी सर, मुझे ना एक क्वेश्चन पूछना था, लीगल एडवाइस आपसे चाहिए थी।
जी ठीक है, नो प्रॉब्लम। जी भाई आप पूछ सकते हैं, आप लाइव है, लाइव होना है।
ओके, बेसिकली माय मिसेस का अप्लाई करना है वीज़ा नेक्स्ट मंथ जून, नेक्स्ट ईयर जून में, और दे आर गोइंग टू अप्लाई indefinite leave to remain.
I understand.
But I'm taking a universal credit as well.
I understand.
But my salary is more than 18,600.
I understand.
It's about like 35,000. So I need to know that do I need to stop taking the universal credit? It's not going to affect my Mrs. visa, or do I need to stop that?
Brother, the answer is very, very straightforward. You don't need to stop universal credit at all. So there's absolutely nothing to worry about in terms of you receiving universal credit as far as the immigration application is concerned for your wife. So the way the Home Office now works is that as long as you meet the 18,600 requirement, and you do, they don't look beyond that. They don't look at the fact that you're receiving universal credit. That's not a problem. You, as somebody who is British, is entitled to receive universal credit. So that's not a problem. What the Home Office simply looks at is, do you earn £18,600 per annum? If you do, your wife qualifies for her leave to remain or her indefinite leave to remain. If you don't, then obviously there's an issue there. But universal credit or any other benefits that you get after you've met the 18,600 income threshold, that doesn't have an adverse impact on the immigration application at all. Brother, does that answer your question?
Yeah, thank you very much.
Yeah, thank you very much for your call. Interesting call. We do get asked that in practice quite regularly, that is the universal credit going to affect your application? The answer is no. There's nothing that says in the immigration rules that the British partner who may be eligible for benefits, nothing that says that the British partner cannot receive benefits. As long as the income threshold is met, then the partner can successfully apply for leave to remain or indefinite leave to remain. But thank you very much for your call. Now, that question regarding money or goods or anything being found on a pavement or elsewhere, so the basic position is this, going back to that old question just before we took the call. In order for you to be able to take it, it has to be, from a legal English law perspective, it has to be something which has been completely abandoned, an old sofa or something. But anything of value, such as a mobile phone, money, clearly has not been abandoned. Somebody's lost it, somebody's forgot it. You can't take that. If you do, it's not a defense to say, I found it. Finders keepers is not a defense to a charge of theft. So you shouldn't take it. Well, practically, it may be that you should hand it in to the nearest police station, but certainly don't keep it. So that's the legal position on that. I thought that's a non-immigration question, which is something that was quite interesting. Right, going back to our questions, we've got a number of questions on WhatsApp, but as always, please do feel free to pick up the phone and to give me a ring live on air. Next question on WhatsApp is this, and this looks like to be one about delay. And the question is, I applied for an extension of my visa in June 2020. So it's been over a year, June 2020. My fingerprints and photographs were taken in August 2020. So even the biometrics were done over a year ago. I, however, still have not received a response. Taking a short break. We're going to be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, if you want to send me a message on WhatsApp or send me a text message, you can do so on the mobile number which appears at the bottom of the screen. We've had numerous messages coming through today, which is fantastic, and I'll be going through them. Please do continue to send your messages in, but you can speak to us live on air as well by ringing the landline number, and your call will be put through to me live on air. What should I now do regarding my application? So there's been a considerable period of time that's passed since the application was submitted, around 1 year mark. What should be done? Well, look, a couple of options. First option, you can always write to the Home Office for an update. I suspect you won't get a response. The Home Office isn't very good in terms of responding to chaser letters where people are asking for an update. Generally, they don't respond to that. And certainly, if you say to them, can you please explain why it's held up? Can I have an explanation as to what's going on? They won't give you an explanation. If you're lucky, you might get a letter saying, your application is still being processed, but beyond that, you're not going to get anything. You're not going to get an explanation as to what's going on and what's causing the delay. What else can you do? The only other option really is to approach your local MP, the local member of Parliament, and ask your local member of Parliament to intervene on your behalf, so they are able to contact the Home Office and find out directly from the Home Office as to what's going on. But again, the problem is this, the response that the Home Office will provide, and certainly in terms of the MP getting involved, the MP will be provided with a response. The response will basically be that the matter is currently in process. It's currently being considered. Again, the Home Office won't go beyond that. They won't give a more detailed answer than that. So all you can do, first of all, is you can write in yourself. That may not result in anything happening. Secondly, if you still don't have any joy, you can contact your local MP and ask your MP to intervene on your behalf. So really, that's what we can do. Even after you've done all that, you have no joy. Unfortunately, there isn't anything else you can do. You can't really take them to court or anything like that. You're going to have to wait. Okay, fantastic. Let's take our next call for the day. Hello, assalamu alaikum.
Hello, assalamu alaikum, brother.
Wa alaikum salam, brother. Thank you for calling.
Yes, but I got a question. Actually, my hearing was cancelled, and the judge has made a 6 weeks adjournal.
Okay.
But they don't give me the hearing. It's been like more than 6 weeks. It's like 12 weeks.
I understand. Do you know why the hearing was cancelled?
date.
Do you know why the hearing was cancelled and why the judge said it'll be listed after 6 weeks? What happened?
Yeah, the Home Office have said that we are not ready.
I understand. Okay, so there was a delay on the part of the Home Office, right? So what you need to do is basically try and get the matter listed. You or your lawyer needs to write in to the tribunal, to the listings department, and basically say to them, can my case be listed as soon as possible? The problem is this.
Okay.
You know, when your case comes out of the list, the problem is it goes back into the normal queue. So it's then listed along with the other cases which have been listed. This is the problem.
They have already listed, but they have listed like they give me the date. It's very delay, like it's very it's going to be like very
far
late.
ahead. This is the problem.
We are aware, yeah.
So you know what the judge says? The judge says the hearing should be listed after 6 weeks. So after 6 weeks basically means that it shouldn't be listed.
No, he said like it's going to be within 6 weeks. He did confirm on that time that you will help.
Has he said that in an order?
Yeah, he said that confirmed. That has been confirmed that you will have another hearing in 6 weeks.
If it's specifically in an order that the matter will be listed.
Because my first hearing, they gave me, it was because I did put expedite request, and that was accepted.
I understand. I think you need to write to the judge then. You need to. If listings won't do anything, the only other way is that you write to.
I did write them many later, but the only thing they say we don't have any availability before that, so that's why it's like a very far. It's 1st of November.
I mean, you've tried everything. You've tried everything. You've tried listings. I mean, the only other suggestion, and I don't think they'll take up on that, is to say, can you move it to another hearing centre? But the problem is, it goes to another hearing centre. You then have the same problem. If they're busy, you still won't get a hearing. To be quite honest, it looks like you're stuck at the moment. All you can say to them is, look, if another slot becomes available, then please move my hearing and put it in. That's what you can say, that if something else becomes available, I'm going to be available to take part in the hearing very quickly. So please, can you put it in? That's the only other thing that you could do.
Yeah, they have said that to me, but that we will try to manage to
But
give
they haven't done it
before the 1st of November. But I don't think so they will do, because it's been already very late.
I know. Look, all you can do is maybe every couple of weeks, maybe write to them and say,
Write to them again.
Write to them and say, look, if it's a free slot available, can you please? Because sometimes you get cases coming out of the list. They might be settled. Somebody might decide not to carry on with an appeal. So free slots do become available. So what you're saying to them is, can you fit my case in when a slot becomes free? That's the only thing that you can do. That's the only way you can get.
My question is, like, if you have the caseworker in the tribunal, in the court, if he said to you that, I have
his hearing, which had been cancelled, it was an expedited hearing. Lucky enough to get it expedited, got cancelled. The judge said we'll list it within 6 weeks, and it still hasn't been listed. The problem is there isn't much you can do. You can keep on writing to the listings officer saying, look, when a slot becomes available, do please ensure that it's a vacant slot which is given to me. The only other thing that you can do is write directly to the judge who dealt with it. The judge might be able to speak to listings to try and get your case slotted in somewhere else, but you're going to have to keep on trying. There isn't anything else that you can really do. But thank you very much for your call, and I do hope that your persistence does pay off and you do get your date quickly. Okay, next question that's come in. It's quite a complex question, really. Caller says basically this, and this looks like it's the financial requirement for making a spouse application, specifically where somebody is in receipt of carer's allowance. So the question is this: please, can you give me a breakdown for sponsoring my wife to the United Kingdom from Pakistan when you're receiving carer's allowance and universal credit? Now, the basic position is this, that where you receive carer's allowance, you don't have to meet the £18,600 requirement. So that strict £18,600 requirement doesn't apply. However, where you receive carer's allowance or any other disability benefit, which is listed in the immigration rules, then although you don't have to meet the £18,600 requirement, you still have to be earning enough money to be able to maintain and accommodate your wife without recourse to public funds. And that's an assessment, a financial assessment that needs to be done. So when you're doing that assessment, and we don't have enough information to do the assessment now, but let me give you an idea that what you look at is how much money does a person need to live on. And in order to work that out, the Home Office uses income support rates. So the Home Office will say, in terms of a husband and wife, how much income support would they have been entitled to? So it's around £110, £115. So that's the money that they need to live on. Plus, If they've got children, then that adds more money in terms of they need more money to live on. And again, there's a formula for working that out. On top of that, you've got to add in the accommodation costs. How much council tax do you have to pay and how much rent you have to pay. In a typical example, let's say where somebody lives with family, there's no council tax to pay, there's no rent to pay, there's no mortgage to pay, and all you're looking at is somebody who's on carers allowance and universal credit wanting to sponsor their husband or wife to come to the United Kingdom. Then it's some very simple calculation. You simply look at what a husband and wife on income support, how much would they need, how much would they get? That depends on the age of the parties, whether they're both over 18, etc., 25, etc. On the whole, it's around the £110 mark. So if that's the threshold you have to meet, then you look at the money you're receiving. You're getting carers allowance, you're getting universal credit. Are you getting enough money there to reach the £110, for example, threshold? If you don't, can you add a part-time job? Or have you got savings that can be taken into account? So it's difficult to give a very precise answer here with the limited information that we have, but there is a formula for working that out. Now, if you do want a more detailed answer, then please do feel free to give me a ring on the landline number, and I'm happy to go through the calculations with you live on air to see whether you're earning enough money or not. But basically, that's the way. Although you don't have to meet the £18,600 requirement, you still have to be earning enough money to be able to maintain and accommodate yourselves without recourse to public funds. And to work that out, there is a formula for working that out. Hope that answers the question. I've tried to do the best with the limited information that I have. Okay, let's look at the next question that's come in. Again, another immigration question. Let me read the question out. I have a question regarding a visa application. Been here for 2.5 years. Sorry, my husband's been here for 2.5 years. His visa is about to expire. We need to extend it. Which form is it that I need to fill in? Please send me a link. Look, basically, when you have a partner who's here from abroad, they complete their 2.5 years, you get into the extension stage. The form that needs to be completed is a form which is called FLRM, Further Leave to Remain Based on Marriage. So it's FLRM. Now, if you Google that, form FLRM, and you should be able to get to that on the government website. So the government website, which will still say it's form FLRM, that's the form that you need to complete. So I understand that, brother. We are taking a short break, and I will address this after we come back. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen, or alternatively, you can send a message on the mobile number which appears at the bottom of the screen. We've got loads of questions coming in on WhatsApp, but as always, do please get in touch with us live on air as well. Now, let's look at the next question that's coming in. Dear sir, we submitted our indefinite leave to remain application in December 2020 and went for biometrics in January 2021 in Birmingham at one of the approved centres. We haven't received a decision yet. What's the waiting time for decision? So this is again a question regarding delay. We've had a number of questions regarding delay and to be honest, in practice, this is something that comes up day in, day out, where clients are chasing for an update. Why is my application taking so long? So going back to the question here, indefinite leave to remain application submitted in December 2020, Biometrics done in January 2021, still waiting for a decision some 8 to 9 months down the line. Now, I can only give you a sort of a general idea. Most straightforward applications are being decided in about 4 months at the moment. More complex applications, or what the Home Office deems to be a more complex application, normally applications based on the 10-year route, etc., they seem to be taking a little longer. They seem to be taking around 7 months, 8 months to be decided. This is an indefinite leave to remain application, so it's not one of those, normally you don't expect it to be one of those complex cases where the application is based on a British child and a contact with a British child or anything like that. It seems like if it's an indefinite leave to remain application, it should have been a relatively straight application where I would normally expect a decision within about 4 months. Look, the decision hasn't come through. What can you do? As I've said before, in answer to another question that we had earlier on, you can write to the Home Office, ask for an update. I doubt it very much that you're going to get much joy. Alternative is you speak to your local MP and get your local MP to get in touch with the Home Office. Now, it may mean that doesn't really prompt, that may not result in you getting your decision straight away, but it may prompt the Home Office to look at your file. So that's what I would do. Write in. If there's no response, go and see your local MP, Member of Parliament, and get your Member of Parliament to speak to the Home Office and get an answer. So that's the position as far as that's concerned. Okay. We've still got so many questions coming in on WhatsApp, which is fantastic. But as always, you can give us a ring live on air as well. Let's look at the next question that's come in about nationality. How long are nationality applications taking at the moment? My experience, nationality applications aren't too bad in terms of processing times at the moment, but we are still looking at around 4 to 5 months for a decision. So, they're not taking 8, 9, 10 months anymore, but at least 4 to 5 months before you get a decision on a nationality application. Second part to the question is this: can a Royal Mail manager act as a professional referee for an applicant for British nationality? That may be a problem. The Home Office list of those who are approved in some places is a bit vague. My view is that may cause a problem because obviously with management you get different levels of management. Very senior managers, directors of businesses obviously can act as referees. The problem is managers at the first rung of management may not be acceptable to the Home Office. So my view generally is if you can try and get your referees, whether it's for a nationality application or whether it's for a passport application, try and ensure that your referees are professional referees, if possible, doctors, lawyers, accountants, nurses, engineers, and so on. The problem is if you submit a referee from someone who is not acceptable, that will delay your application. My initial thought is this, that a Royal Mail manager may not be acceptable as a referee. So hope that answers the question. Next question that's come in, a slightly different question regarding direct payments for carers. And the question is this, and this is about somebody who comes to care for let's say a family member, and the council is to pay for that. The question is this: the council are refusing to give us direct payments. Is there any way of appealing against that decision? We're not happy with the carers. We want to employ our own carers. Now, my understanding of this field was this, that it's up to the individual to decide whether they want direct payments made to them and for them to engage carers, or whether they want the council to pay the carers directly. and it's unusual to find that they're not prepared to give direct payments. If you're not happy with it, raise a formal complaint. If there's no appeal process, and I'm not 100% sure of that, at the very minimum, if there's no appeal process, you should raise a formal complaint, which will at least get them to look at this issue. If you're still not sure, then the best agency to approach in these kind of issues is normally the Citizens Advice Bureau, or alternatively, it's a council matter. You could approach your local councillor and ask your local councillor to intervene on your behalf. So if there's no appeal, you can complain, you can go to the Citizens Advice Bureau for further advice, or ask your local councillor to take up this issue as well. Hope that answers your question on that. But if you're not sure, please do come back to me. More than happy to make further inquiries and give you a more detailed answer on that later on. Okay. Now, another question, slightly complex and unfortunate. Long question. The inquiry is this: my wife's cousin was taken to Pakistan and was left there with her 6-year-old baby. I think the background to this must be this, that the wife's cousin came to the United Kingdom, must have been under a spouse visa, and then she's taken back to Pakistan, I suspect, under false pretense. She might have been told, we're going for a holiday, we're going to come back. But in any event, the cousin's taken back to Pakistan and left there with a baby girl. And then the husband's taken away the 2.5-year-old son. So one child's been left there, the other child's been left here. Passport's been destroyed. Now, I think many years on, I understand that the girl is now 18 and got her British passport. Mum's got no passport. She was in the UK for 2.5 years before she was tricked and made to go back. Is there anything that Mum can do? The problem is this: Mum could have done something many, many years ago. You know, when this unfortunate set of circumstances incident occurred, when Mum's taken back to Pakistan with the baby girl, the son's left here. What Mum could have done is, once the baby girl had a passport, then applied for a visa to come to the UK in order to come with the child. I mean, she wouldn't be with the spouse. Obviously, that relationship's broken down. But the child is British. The child's entitled to live in the UK, and the child wouldn't be able to live in the UK without Mum. So that could have been a route into the United Kingdom for Mum. Now that the child is now 18 and no longer a child as far as immigration law is concerned, Mum can't use that anymore. And immigration law now doesn't help her. Can't rely on what happened probably about 15, 16 years ago to get leave to remain in the United Kingdom. Something could have been done at the time. It can't be done now. Very sorry to give you that bad news. Okay, got another question coming in. I know we are coming to the end of the show. I've still got quite a few questions. Let me try and get through them as best I can. Next question that's come in. I separated from my husband after 15 years of marriage, moved to a private property with 3 children. It's been 10 years. Found out 4 years ago that he was cheating whilst we were both married. He's got another son. The marital home was mortgaged during marriage. What is my right? Now, basically, the position is, in terms of marriage breakdown and finances, when you're looking at finances in terms of who gets what the husband gets, what the mother gets, what you have to remember is the court won't look at who is to blame for the marriage breakdown. And I understand what you're saying here about you suspecting that the husband was cheating, etc. But the court won't look at that when it comes to finances. So the court doesn't look at who's to blame, because practically, if the court had to do that, it'd be forever trying to work out what's happened, who said what. So the court doesn't look at that. What the court does is look at the parties' circumstances. Now, if you've got 3 children, if they're under the age of 18, then I suspect that you've got a bigger share of the matrimonial home, because the financial burden on you is much greater. Not only are you looking after yourself, you're looking after 3 children. So when the assets are apportioned, you would normally get a greater share. So if your finances haven't been sorted out, you do need to speak to a family lawyer to try and sort that out. But in answer to your question specifically, who is to blame, who did what, isn't something that the court will take into account. Hope that answers your question. We are coming to the end of the show. Let me just try and fit one more question in. Salam's question is regarding the financial requirement for a visa extension, FLRM extension. Can it only be met by a UK partner? On an extension application, in terms of the financial requirement, the £18,600 requirement, you can look at the income for both parties, the husband and wife. You can combine it, or it can be one party's income. Hope that answers that question. Obviously, I've given you a very short answer. If you're not sure, please do give us a ring next week. That brings us to the end of the show. We'll be back next week at the same time. Assalamu alaikum.